morning and welcome to Archer's webinar, The 10 Amendments. Our plan today is to provide you with a whistle-stop tour of the 10 most common amendments that we see in JCT and NEC contracts. We have focused today on the JCT D&B and the NEC 4. We hope to have some time at the end for a couple of questions that we've received. For anyone who doesn't know us, we're a firm of construction solicitors based just outside Colchester and have just celebrated our second birthday. There are 6 partners and we were all senior members in a construction team of a large regional firm prior to setting up Archer. We're now a strong 17 headcount, and for those of you who don't know, we specialise in both contentious and non-contentious construction work. So I'm delighted today to be joined by Hanna McNab, who is also a partner at Archer, and also Sarah Lester, who is a senior associate here. I'll now hand you over to Sarah.
Thank you, Ruth. Okay, so the first common amendment we are going to cover is design responsibility. Whilst this is by no means a new topic, it remains a very important one because of the significant potential and very often costly risks involved where a contractor is expected to accept full responsibility for the design of a project. So we're going to take a look at the JCT clauses first, and then we'll come on to the equivalent position under the NEC contract. As Ruth mentioned, where we're talking about the JCT contract in the webinar, we're talking about the design and build form of contract, and where we're talking about NEC, we're talking about the NEC for engineering and construction contract. So firstly, looking at JCT, there are a number of places where design responsibility is dealt with in the JCT contract, so we're going to cover the main ones today, although there will often be a few others that aren't covered here. The first amendment tends to be to the third recital, and as you can see on the screen, the standard JCT wording is in black, and that tends to be completely deleted and replaced by something similar to the red text. To understand the impact of this amendment, it's important to understand how the JCT contract works in its unamended form in terms of design responsibility. So the employer retains responsibility for the employer's requirements and any designs contained in them, and the contractor is then responsible for the contractor's proposals and any design going forward. The effect of the amendment to the third recital is that the contractor becomes responsible for the entirety of the design, whether that design has been prepared by them or not, and whether it's included within the employer's requirements or in the contractor's proposals. The next key amendment in relation to design responsibility are found in the clauses dealing with discrepancies and divergences. So starting with clause 2.11, as you can see, the standard position that the contractor isn't responsible for the contents of the ERs is reversed, and that's replaced with a clause that now states that the contractor is fully responsible for the entirety of the design, whether or not carried out by or on behalf of the employer. So when considering the discrepancies clauses, it's again important to consider the standard JCT position first, and that is best shown at clause 2.14. So as you can see from the extract on the slide showing the unamended version of clause 2.14, the position under JCT is that the contractor takes responsibility for a discrepancy or diversion in or between the documents that they've prepared. So that's the contractor's proposals and the contractor's design documents going forward. But where the discrepancy is within the employer's requirements, any changes that need to be made to deal with the issue are treated as a change. They're a variation, entitling the contractor to both additional time and loss and expense. This clause is usually deleted and replaced with something along the lines of the following, which I'm sure is very familiar to many of you. So in circumstances where the contractor has accepted full responsibility for the design, including that contained within the ERs, the standard JC position, of course, doesn't really make much sense. So these clauses are usually replaced with a clause similar to this one, which essentially makes the contractor fully responsible for all discrepancies, divergences, and even inadequacies within or between all of the documents, including the documents provided by the employer. So moving on to how the NEC contract deals with design responsibility. The contractor's design is dealt with by reference to the scope, as with many things under NEC. The contractor has responsibility for the design to the extent set out within the scope. As you can probably guess from the flavour of this topic, the scope generally makes the contractor entirely responsible for the whole of the design of the works. And clause 21.1 tends to be amended as shown on the slide. So as with the JCT position, the unamended NEC gives the contractor an entitlement to claim additional time and money by way of a compensation event where changes to the scope are necessary because there's an issue with the information in the scope that's been provided by the client. This is usually amended at clause 21.1 and then again at clause 60.11, which is the relevant compensation event. With the effect that the contractor is responsible for the entirety of the design contained within the scope, whether prepared by the contractor or by the client. Clause 61.1, so the compensation event is usually then amended to further clarify that any instructions changing the scope that are made to deal with issues within or between the documents forming the scope won't amount to a compensation event. So very similar to the JCT position, really. So to summarise, most NEC and JCT contracts are amended in a similar way. The overall effect of making the contractor entirely responsible for the design of the works. This includes the design that has been prepared by the employer, or more accurately, the employer's consultants, often before the contractor is ever involved with the project. Whilst this does significantly alter the risk profile of the standard forms, this is the market standard position and has been for some time. And in a market that's principally driven by developers and more often their funders, this isn't something that's likely to change anytime soon. So if you are a main contractor, the likelihood is you'll be accepting full design risk. So how do you mitigate this risk? Firstly, if you're intending to rely on the information within the ERs or the scope, you'll need to establish a contractual link between you and the consultants who have prepared that design. This is usually achieved by novating the appointment from the employer to the contractor. So the contractor steps into the shoes of the employer for the purposes of the appointment. If there isn't going to be a novation, the contractor would be sensible to obtain a direct collateral warranty from the relevant consultants for their benefit. Or if that's not available, the option would be to employ a new design team, ideally to take responsibility for the existing design, although as I'm sure many of you can imagine, that can be a tricky thing to negotiate. Another option is to focus on a two-stage contracting approach, which is very favourable at the moment and has been for some time. The contractor is engaged at an early stage and then can have an influence over and involvement in the design from the beginning. It obviously goes without saying, really, a full review of the ERs and the scope is necessary. We often see contractors including a derogation schedule or something similar within the contractor's proposals or within their scope. Most contracts that pass on full design risk make it clear that the contractor is responsible for all of the documents, including discrepancies between them. So simply including a derogation schedule isn't likely to be sufficient unless the contract also clarifies that that takes precedence over all other documents. So do take care when dealing with it that way. Finally, a contractor will need to consider how they're engaging their supply chain and ensuring that wherever appropriate design risk is passed on and that the supply chain is engaged at the earliest stage. So our second key amendment is the requirement to provide additional security by way of performance bonds and PCGs and also collateral warranties. Clause 7.3 of the JCT contract is the clause that deals with the provision of bonds and PCGs, and that includes an obligation on the contractor to provide either or both a performance bond and a parent company guarantee. Whether both or either of these obligations is to apply is indicated in the contract particulars. The key amendment that's made is the one that is shown up there on the screen, and that is to make the provision of the bond or guarantee a condition precedent to payment. That gives the employer the authority to withhold all sums due to the contractor until these documents are provided, and they're usually required upon execution of the contract. The other key amendment under JCT in relation to PCGs is to require that they're provided by the contractor's ultimate parent company. The obvious aim being that the PCG is provided by the entity who is likely to have the most assets. Whilst this is perfectly understandable from the employer's perspective, it may not be acceptable from the contractors. Moving on to how the JCT deals with collateral warranties. So that is dealt with in clauses 7C to 7E of the unamended JCT. As with the requirement to provide bonds and guarantees, the key amendment that is made is making the provision of warranties a condition precedent to payment. The biggest issue for a main contractor is that their obligations to provide collateral warranties includes an obligation to procure them from their supply chain. And this can obviously be easier said than done, as I'm sure many of you know. The other key amendment to the standard JCT terms in relation to warranties is to extend the group of beneficiaries who are entitled to the benefit of a warranty, and also to include a bespoke form of warranty rather than the obligation to provide the JCT standard form, which is what the standard JCT contract requires. So under the NEC contract, the obligation to provide a bond, parent company guarantee and collateral warranties, which quite unhelpfully under the NEC contract called undertakings, is set out in the secondary option clauses or the X clauses. And whether or not these obligations apply will depend on whether the contract data incorporates the relevant X clause into the contract. As with the JCT contract, the key amendment made to NEC is to make provision of these documents a condition precedent to payment. Under NEC, unlike JCT, a PCG is always required from the ultimate holding company, so it's just something to bear in mind. So given the current issues in the market with high levels of insolvency, both at the main contractor and subcontractor tiers, the requirement to provide additional security documents, either in the form of bonds or PCGs or both, is on the rise. This often stems from funders who will require the security to be in place as a condition of the funding. Similarly, the requirement to provide collateral warranties is extending to a greater number of parties. So there's a rise in contracts demanding, as well as the usual designer collateral warranties, workmanship only collateral warranties. So the obligation on the main contractor to procure warranties extends to a far greater element of the supply chain than just subcontractors and consultants with responsibility for a material element of the design, which is sort of the traditional position. The key issue really for parties responsible for providing these documents is that they're almost always made a condition precedent to payment, and that is particularly problematic when this requires reliance on a third party, so provision of, well, all of them really are reliant on third parties. So if you are the main contractor, again, unlikely that this obligation is going to go away. So how can you mitigate this risk and manage it? Well, security documents, so PCGs and bonds, often a main contractor is required to provide both a bond and a PCG. Given these documents are both principally to protect against insolvency risk, arguably two forms of security protecting against the same risk is excessive, although a developer who's had to deal with an insolvent contractor recently may not agree with that point. It's also important to consider whether it is actually possible to provide these documents. Provision of a PCG obviously depends on how the company is structured and whether the guarantor is prepared to give the guarantee. In terms of a performance bond, the contractor will need a bond facility in place to be able to provide a bond, and the surety will have to have agreed to provide the bond in the required terms. And any of you who have tried to procure a bond recently will understand that the bond market is incredibly difficult at the moment. In terms of collateral warranties, it's important to understand who the beneficiaries are and to ensure this obligation isn't too wide. And from the main contractor's perspective, really you need to understand who you're being obliged to provide these warranties from, so ensuring that it's not from essentially the entirety of the supply chain. There's almost always strict timelines within which bonds, PCGs and warranties will have to be provided before the penalty of non-payment will kick in. So it's really important that the terms of these documents are negotiated and agreed before entering into the contract. As I said above, this is particularly important with regards to bonds at the moment, because you don't want to be stuck with a position where you've got to provide a bond that you can't actually procure. So the final amendment that I'm going to consider is how responsibility for existing site conditions is dealt with. So under JCT, the contract doesn't actually expressly deal with who takes responsibility for site conditions, but the contract is very often, almost always, I would say, amended as shown below. And the effect of this is that the contractor takes full responsibility for all site and ground conditions, whether such conditions are foreseeable and without any ability to rely on any existing site investigation surveys or other documents that the employer may have provided. These clauses, as with the example clause here, generally assume that the contractor has had the opportunity to inspect the site, which is often not the case in reality. The NEC approach is different. So the NEC contract deals with responsibility for site risk expressly, and in its unamended form, the risk is shared between the parties, with the contractor being entitled to a compensation event, which is the clause shown on this screen here, where unforeseen physical conditions are discovered, which may cause delay or extra cost. This compensation event is almost always deleted. Clause 60.3 sets out that the risk is shared on the basis that the contractor accepts the risk for site conditions that they should reasonably have foreseen, based on the information provided by the client and also information that is readily available about the site. And the client takes the risk on any unforeseen site conditions. Again, clause 60.2 is usually deleted and amended to pass the full risk of site conditions onto the contractor. And finally, under clause 60.3, the contractor is entitled to the benefit of the most favourable site information that they've been provided where there is any ambiguity or consistency in that information. Again, this position is very often amended as shown here, which essentially confirms that the contractor is not entitled to rely on any of the existing information provided by the client, so very similar to the JCT position. The overall effect of the amendments to these clauses is that the contractor takes full risk on all site conditions, whether those are foreseeable or not, and the contractor is generally not entitled to rely on any existing surveys. Whilst the JCT and NEC standard positions are quite different when it comes to dealing with site conditions, these contracts are generally both amended in a way that makes the contractor fully responsible for the existing conditions of the site. The definition of what amounts to a site condition is itself often very wide, so this can be a high-risk amendment for the contractor to accept, and it's one that is often the subject of negotiation before a contract is agreed. As we mentioned before, the standard JCT position is to be silent on this matter. What contractors must bear in mind when negotiating this point is the common law position, which is where a contract is silent, the contractor is deemed to take the risk for adverse site conditions. So it is not enough simply to remove amendments or leave the JCT standard position, but express clauses should be included to confirm the extent of the risk that the party is prepared to accept. That is everything from me. I am going to hand you over to Hannah.
Thanks, Sarah. So I'm going to move on to amendments that are important during the course of the works and why it is essential that the individuals running contracts are aware of the stringent requirements that we see on a day-to-day basis. Now, the first amendment I'm going to deal with relates to a contractor's request for an extension of time to the completion date for the works. Looking at the wording in the JCT form of contract, this requires the contractor to give a notice to the employer forthwith if and whenever it becomes reasonably apparent that the progress of the works or any section is being or likely to be delayed. The contractor is to set out the material circumstances, including the cause or causes of the delay, and shall also identify any event that is a relevant event. Now, it's extremely unusual for this clause to remain as drafted. In nearly every JCT contract we see, the requirements for the EOT notice are amended, and most commonly compliance with the notice requirement is a condition precedent to an EOT being awarded, which is what the amendments on the slide provide for. So what is a condition precedent clause? Well, in very simple terms, it is a clause in a contract which provides that performance of the contract as a whole or certain obligations under the contract will only come into force if and when specified conditions are met. It is important to note that no special form or words are needed to use to create a condition precedent. In particular, the phrase condition precedent itself does not need to be used in order for the clause to operate in this way. However, it must be clear from the wording that the performance is conditional upon the specified event occurring. So a condition precedent clause should cover the following matters. A deadline for fulfilment. There needs to be a set date and not put the parties under an indefinite obligation. It needs to set out the consequences of non-fulfilment. So the clause needs to state what happens if the condition is not satisfied. And the clause also needs to set out the steps to fulfill the condition. A condition precedent clause should specify exactly what is required for the condition to be fulfilled. So just looking at the amendments on the screen to the standard JCT wording, these seek to make the contractor's notice of a delay a condition precedent to receiving an extension of time. The amended wording adds a deadline for fulfilment because the notice needs to be given no later than 14 days after it becomes apparent that the works are being delayed. The amendment then goes on to say that the notice is a condition precedent to an entitlement to an EOT, making the wording clear of the intention, and also states that if the notice is not given in accordance with the requirements, the contractor shall lose any entitlement to an EOT. So the amendments to this clause make the giving of a delay notice a condition precedent to the contractor's entitlement to an EOT under the contract. Now, with NEC, the position is slightly different. The NEC clause that deals with compensation events is already drafted in such a way that if notice is not given, there is no change to the completion date or a key date, so is arguably in practice a condition precedent clause already. So clause 61.3 on the slide shows the standard NEC position, that if a compensation event is not notified by the contractor within 8 weeks of becoming aware that the event has happened, the contractor loses his entitlement to any additional time, or, as I'll come on to shortly, money. Beware, however, the period of time to give this notice is more often than not changed to a reduced period, commonly 4 weeks. Now, in addition, the standard NEC wording gives the contractor a partial get-out-of-jail-free card by saying that the notification is not required if the event arises from the project manager or the supervisor giving an instruction or notification, issuing a certificate or changing an earlier decision. As you might expect, this wording is removed in most amended forms of NEC, so the contractor must give the requisite notice of the compensation event, no matter how it has arisen. Otherwise, there will be no entitlement to a change to the completion date or a key date, or indeed the prices, which again, I'll come on to next. So why is all of this important? Well, if the contractor is seeking a change to the completion date, but the condition precedent clause has not been complied with, the contractor will not be entitled to the EOT claimed. It really is as simple as that. It does not matter how strong the contractor's claim is. The position could be entirely clear-cut. However, if the contractor has not notified the employer of the delay in accordance with a condition precedent clause, the employer is not obliged to award a further time to complete the works. It is therefore key that those individuals who are running projects on the contractor side are aware of any condition precedent clauses relating to time and ensure that the correct notices are given to avoid losing any entitlement under the contract. When in doubt, issue a notice. It is far better for a contractor to issue a notice than not to protect its position in the future. We see contractors fall foul of condition precedent clauses frequently, and it can be easily avoided if those people actually running the works are aware of the notice requirements and the consequences if such notices are not given. I'd also suggest that the employer's agents and project managers or anyone administering contracts that contain condition precedent clauses are aware of the requirements that must be met before awarding any additional time, to avoid any arguments of waiver, for example, if awards are given despite the contractor not complying with these clauses. This is obviously going to help the employer's position later on down the line when the lawyers get their hands on the dispute. Now, I'm just going to stay on this slide whilst I seamlessly move on to the next amendment, which is condition precedent clauses for loss and expense under JCT and a change to the prices under NEC. I'm not going to deal with this amendment in detail, as the same principles apply as with condition precedent clauses for time. But NEC deals with time and money in one go. So the wording of clause 61.3 applies to a change in the prices, as well as a change to the completion date or a key date. If notice of a compensation event is not given within the requisite period of time, which is often reduced to 4 weeks, then the contractor cannot claim an increase in the prices, nor indeed an extension to the completion date, as I spoke about just now. As we know, JCT operates differently to NEC, and a contractor's entitlement to loss and expense is set out at clause 420 of the JCT D&B. Now, the JCT form merely requires the contractor to notify the employer as soon as the likely effect of a relevant matter on regular progress or the likely nature and extent of any loss and expense arising becomes, or should have become, reasonably apparent to him. As you may expect, this clause is commonly amended. The most common amendment is to turn this clause into a condition precedent clause, which is what the amended wording on the slide seeks to do. The amendments provide that notice of the effect of a relevant matter must be given within 14 days of the relevant matter occurring, and if notice is not given, the contractor is not entitled to payment of any loss and/or expense. Now, as discussed in the context of a contractor's entitlement to an EOT, if there is a clause making the giving of a notice for loss and expense a condition precedent to payment, then this must be adhered to. Many a time have we seen a contractor put in a hefty loss and expense claim at the end of a project whereby the costs have legitimately been incurred, but because the requisite notices were not given at the time, such loss and expense was not able to be recovered from the employer. Again, on the flip side, EAs, PMs and the like need to be aware of these clauses too, to ensure that loss and expense claims are not valued and indeed paid by the employer if the conditions have first not been complied with. An employer won't thank you if it has had to pay a certified sum for loss and expense if there is actually no contractual entitlement to do so. Next up, everyone's favourite topic, payment. So the extent to which payment clauses are amended varies. However, it's safe to say we very rarely see unamended payment clauses. Parties will most likely change the payment periods, but what I'm going to look at now are the amendments made to the JCT and NEC forms in relation to the contractor's application for payment. So clause 473 of the JCT D&B requires the contractor to make a payment application stating the sum the contractor considers to be due and the basis on which that sum has been calculated. The due date is then worked out from when the contractor issues the application, whether this is before or after the interim valuation date. In the amendment on the slide, this clause has been heavily changed. The requirement to issue an application is stated to be a condition precedent to payment, meaning that if the contractor does not apply for money, the employer is not obliged to make payment. The amendment then goes on to set out the specific requirements for the application itself, which include when it must be issued, being at least 3 business days before the interim valuation date, who it must be sent to, and what details it must contain. Now, the amendment on the slide is particularly onerous as it requires a written report to go with the application, setting out the details of each activity or element of the works completed, an updated programme, and details of payments made to any subbies. So whilst it is arguable whether this clause is in fact drafted as a true condition precedent clause, the requirements for what is needed in an application are clear, and if the contractor does not comply with them, he could find himself without payment from the employer for that month. Now, the amendments we commonly see to the NEC requirements for an application for payment are very similar to those in a JCT. So the standard NEC form just requires an application for payment to be issued at any time before each assessment date, setting out the amount the contractor considers is due at the assessment date. The application needs to include details of how the amount has been assessed and needs to be in the form agreed between the parties in the scope. Now, the amendment to this on the slide requires the application to be detailed and to be issued not later than 7 days before each assessment date. The application must also include sufficient information and documents to enable the project manager to verify the sums claimed. Further, the application will be invalid if it does not comply with these requirements. Now, with both sets of amendments, the contractor cannot simply issue applications for payment when it likes, setting out the sum claimed and how the sum's been calculated. If they do, such applications would be invalid, resulting in no payment to the contractor for that interim payment cycle. Again, it is therefore key that the person issuing applications for the contractor is aware of the requirements and ensures that these are complied with, because if they are not, the contractor will not be paid that month. It's also important that the EA or PM is aware of these requirements, so he or she doesn't inadvertently accept an application for payment which is non-compliant with the terms of the contract. So the last amendment I'm going to look at is not strictly an amended clause, but rather a new clause that we commonly see added to contracts in an attempt to allow the employer to omit works and place them with an alternative contractor. So under the JCT D&B, the employer is entitled to omit work. However, there is no provision for the omitted work to be given to others. So the amendment we often see is a new clause 5.8 in the changes section. In essence, it provides that if a change results in any works being omitted, then the employer can deduct an appropriate sum from the contract sum and can instruct others to carry out such omitted works. The wording goes on to say that the contractor cannot terminate its employment under the contract because of any such omission. The omission cannot be construed as a breach, and the employer is not liable for any costs, losses, damages, or expenses suffered because of the omitted works. The NEC additional wording adopts a similar approach. The clause is often included at the end of clause 14.3 of the NEC, which gives the project manager the right to give an instruction to change the scope or a key date. The additional wording, as seen on the slide, allows for any element of the works to be omitted and for others to be instructed to carry out such omitted works. If this does occur, the employer is not liable for any losses arising from the omission, and no change to the scope shall vitiate or invalidate the contract. So why is this clause important? Well, this clause potentially gives the employer the right to omit large parts of the works and give them to someone else without any recourse for the contractor. This gives the employer flexibility for the works, but it's not so great for the contractor if, halfway through the project, the employer omits all remaining work and gives it to a competitor of the contractor, leaving the contractor out of pocket for its profit for the rest of the works. Now, I say this clause potentially gives the employer this right, as it doesn't seem the courts are too keen on these sorts of clauses, and it is at least arguable whether they would be enforced or not. So 2 cases from the early 2000s looked at this point. The first is Abbey Developments and PP Brickwork. Here, the court held that the contractor had a duty to carry out the work it contracted to do and a corresponding right to be able to do so. The employer could not escape a bad bargain by the use of the omissions clause. Now, the court went on to say that clear words are needed in a contract to enable the employer to remove work from the contractor to simply have it done by someone else. And those words did not appear in the contract in question in that case, but are, of course, included in the amendments on the slide. The Abbey Developments judgment was approved in a later case of Stratford Say Estate Trustees and AHL Construction Limited. Now, in this case, the court held that the employer's power to omit works was limited, and the employer couldn't change the basic nature of the works by omission. However, again, there was no express wording in the contract in question allowing the works to be omitted and carried out by another party, unlike the amended clauses here. So regardless of whether it is arguable if the specific clauses would be enforced by a court, this is an amendment to look out for, and contractors need to be mindful of it. It may be one of those amendments that is unacceptable to the contractor in question because of a huge level of uncertainty it gives. Alternatively, the contractor may wish to try and negotiate this clause to provide that, yes, the employer can omit as much work as it likes, but if it does so, the contractor is entitled to be paid the profit it would have made on the omitted works. So that's my 4 amendments done. I'm now going to pass over to Ruth for the remaining 3.
Thanks, Hanna. So my 3 amendments nicely lead now into termination at will and recovery, which, as I say, nicely leads on from the omission of works clauses that Hanna just spoke about. So we are asked to advise on termination time and time again, and the termination provisions are commonly amended in standard forms because they give the employer, or in the case of a subcontractor, contractor, some flexibility to terminate. Just to be clear, it's the employment which is terminated under the contract, because a number of the clauses of the contract survive termination. For example, the contractor remains liable for defects, notwithstanding the termination. Now, what I'm going to be talking about today is termination at will. The term termination at will means that parties are able to terminate if they choose to do so, without having to identify and prove a default of the other party to validly terminate. You may ask, why is this such an issue? If you are terminated and you'll be paid your loss of profit for the balance of the works on termination? Well, the answer is that the clauses are often drafted to exclude a right to claim loss of profit on termination at will. The risk of terminating, if you choose to do so, without a termination at will clause would leave the terminating party open to a claim for wrongful termination with an associated loss of profit claim for the balance of the contract works, unless that person terminating can prove there's been a default. The key is to ensure with these clauses that any clauses that deal with termination at will are replicated in the downstream contracts. As a contractor, you do not want to be in a position where you've been terminated at will under the main contract with no right to claim loss of profit, and then you have no equivalent termination at will provision in your subcontracts, which means as the contractor, you are liable for the loss of profit from each of your subcontractors, and you have no way of recovering that upstream. So I'm going to start with JCT now. The clause on the slide is a pretty standard clause that we see added to clause 8.4, which is termination by the employer. The notice periods will vary from 24 hours to a month, with the employer always wanting a shorter period of notice as possible. Once a decision is made by that employer to terminate the contractor, that employer just wants them gone from site without having to see out a few weeks or a month, with them still on site doing the bare minimum, which potentially causes delay to the project. Whereas the contractor will want to have a longer period to demobilise and get their affairs in order with their supply chain. The clause also makes clear that in terminated for no fault, the employer is not liable for any of the contractor's losses which flow directly or indirectly from that termination, which, as I say, is different to a common law position on termination. So, looking at NEC, like many provisions in the NEC, the termination provisions are very formulaic. And what the NEC contract provides is a number of reasons, capital R reasons, because they're referenced to R and then with a number. And then it provides a termination table which lists, depending on the reason for termination, the procedures to be adopted and how the termination account should be assessed. As to the assessment on termination, clause 93 sets out 4 heads of assessment, referenced as A1 to A4. A1 and A2 are essentially heads which value the work on termination. A3 is for a deduction to be made for the employer's forecast additional costs to complete. So this A3 is often used where one of the termination reasons is in relation to insolvency. So the employer wants to be able to recover the additional cost of employing others. And A4 is essentially the loss of profit claim. Now, option X11 in the NEC 4 is often utilised but amended as per the slide. So the effect of the amendment, as shown in red, is that the employer can terminate for a reason other than that set out in the termination table, i.e. doesn't have to prove insolvency, doesn't have to prove failing to proceed regularly and diligently, and therefore the employer can terminate at will. And in doing so, the employer will only be liable to the contractor for the value of the works at termination only, and not the A4 head of loss, which is the loss of profit. So option X11 is a new option in the NEC ECC in NEC 4. Previously under NEC 3, clause 90.2, which is the clause which is the pre-clause before the termination table, and provided the employer could terminate for any reason, and termination for a reason other than the capital R reasons listed in the contract would require payment of A1, A2 and A4. Once again, this was often amended to remove the reference to payment of A4 in the termination table. So next clause I'm going to be talking about is changes to statutory requirements. So the basis upon which and the party who takes the risk for changes to statutory requirements after a certain date is often amended, or should I say watered down, from the standard form position. Both JCT and NEC standard forms have a specified date where the risk for changes in statutory requirements or changes in the law shifts from the contractor to the employer in the standard form. In the JCT, the date is referred to as the base date, and in NEC, it is the contract date. As a result of the risk shifting to the employer after a certain date, the employer will then be liable for the cost and time implications of any change which is necessitated as a result of the change in the statutory requirements or the law. The amendments of both forms of contract are drafted here to try and water down that risk to the employer of changes to statutory requirements after the base date. So in JCT, the amendment is clause 2.15 and the associated relevant event clause that you can see at the bottom of the slide, 2.26. And what this does is it adds a foreseeability caveat to the risk of changes in statutory requirements shifting to the employer, such that where a change to the statutory requirements could have been reasonably foreseen as at the base date, the contractor will not be entitled to a change under the contract, which would therefore not entitle the contractor to the cost of the change or any extension of time. Now, this is an objective test and one which is adjudged by reference to an experienced contractor, and not what the particular contractor says it did or did not say it foresaw as at the base date. And we've seen a number of cases recently going through the courts which talk about the question of what an experienced contractor could reasonably have foreseen at the time. So turning then to change to statutory requirements in NEC. Under NEC, it's option X2. It's a secondary option, so you have to select it in order for it to apply. And it deals with changes in the law. In order to establish entitlement, a general contractor needs to consider what was the position at the relevant date, is what changed a law, in inverted commas, as set out in the contract, are there any contract-specific issues, i.e. notification, and what is the actual effect on the works, and did it have any change? So NEC 4 contains a new compensation event as follows. It says a change in the law of the country in which the site is located is a compensation event if it occurs after the contract date, if the effects of the compensation event was to change in order to reduce the total defined cost, the prices are reduced. So when selected, clause X2 therefore places the risk of change in the law on the client rather than the contractor, which is where it lies by default. Save where something became illegal, which would entitle the contractor to an instruction anyway under clause 17. So X2 does not define what the law is. The NEC guidance notes suggest it would include a national or state statute, ordinance, decree, regulation, including building or safety regulations, interestingly, and a bylaw of a local or other duly constituted authority or delegated legislation. And general dictionary definitions emphasise the need for a law to be issued by a state-sanctioned authoritative body and to be enforceable. Once again, the amendment shown on the slide adds a caveat to the employer's risk by reference to what being reasonably foreseen by a competent and experienced contractor. If it could have been reasonably foreseen, then the contractor is not entitled to a compensation event in the event of change in the law. So the last one that I'm going to be talking about are fluctuations. A couple of years ago, nobody ever mentioned fluctuation provisions. Nobody ever really even looked at Schedule 7 of the JCT. Since the cost of materials and labour has skyrocketed, those who signed main contracts a year or two ago are now dusting off their contracts to see if fluctuations applies. In the absence of fluctuations clauses, the risk of inflation is borne entirely by the contractor, and any variation of costs due to inflation is extremely unlikely to affect the contract sum. Whether it is appropriate to include fluctuation clauses is a matter for the parties to assess in the context of each project and based on factors such as type of activities, materials to be used, supply chain stability, geographical location, and simply, supply and demand. So as to the fluctuation options in JCT, it provides three approaches. So option A deals only with contribution, levy and tax payable as an employer. So this option will not help with what I've been talking about, materials costs, the labour increase, labour shortages. Option B, which allows the contract sum to be adjusted for fluctuations to the cost of labour, materials, goods, fuel, electricity, and that includes changes to taxes and statutory duties affecting these. So that's the one that people are pushing for at the moment. Option C just uses formula rates to calculate the adjustment to the contract sum. And under option C, the fluctuation adjustment formula is based on indices that measure the average fluctuation over a defined period. So option A is the default position and will apply in the contract particulars unless the contract expressly provides that fluctuations do not apply. And you can see that in the contract particulars that are shown here on screen. There's a little bit there in italics and brackets, which says basically option A will apply unless it says that it doesn't apply. Options B and C will only become operative by actually completing the contract particulars to confirm that one or other of those options applies. And note that if any of the options are operative, the fluctuations can be increases, but there can also be decreases as well. So there is a risk there that if you're signing up to a contract now and the price of steelwork does miraculously decrease, and you go for an option B, then you are taking the risk that you will, and there'll be a reduction in the contract sum to allow for that price decrease. So the amendment as shown on screen is pretty typical in JCT. The amendment strikes through fluctuations in the contract particulars for clauses 4.2, 4.12 and 4.13, which are the payment provisions, which tell you how to calculate the contract sum, and they delete Schedule 7, which sets out the fluctuations options. And the amendment as shown on there means that none of the options for fluctuations actually apply. So I'll come on to NEC now. There is an equivalent provision X1, which is a secondary option clause, which the parties have to expressly incorporate into the contract data. So a secondary option clause, you have to actually expressly do it. This clause is not usually amended and provides for only one option for fluctuations. If you can see the wording on the slide, it says that that fluctuation is based on an index price adjustment against inflation. And so the practicality of actually using it is possibly quite limited, and it's certainly extremely difficult to administer. So that is all actually for us in relation to the presentation this morning. I hope you enjoyed it. Hopefully that has given you a little bit of a whistle-stop tour in relation to the amendments that we commonly see, the amendments that when we're acting for clients, we often include if we're acting on the employer side. If we're acting on the contractor side, we obviously advise in relation to the effect of those clauses and potentially try and negotiate them. And we also see those a lot on the dispute side as well, especially when we're looking at condition precedents and when we are looking at termination as well, when we get a phone call from a client wanting to terminate. All of these clauses apply really both to the non-contentious advice we give and also the contentious advice we give. So we've had a couple of questions in. We also had a couple of questions in advance of this morning One question that we've been asked in relation to protecting from insolvency. We are feeling here that there have been some large insolvencies recently of large main contractors, and we're definitely feeling there are a lot more questions being asked. Definitely lots more questions being asked in relation to insolvency and how to protect their position. Now, before I come on to kind of PCGs, etc., I think the one way that we have found especially is that shortening payment terms is never going to be, felt safe, but, clients are looking for shorter final date for payment.
Yeah,
most certainly. Some people talked about fortnightly payment applications, but that's quite tricky to administer. But I know definitely we've seen a lot of kind of shortening of payment terms, and also dealing with suspension. I think you've found, haven't you, that a lot of people are getting a bit more on top of the lack of payment by the final date for payment.
Yeah, so if you haven't been paid, rely on your entitlement to suspend the works. Don't just carry on carrying out the works. We're racking up more costs and not being paid for them. We are advising clients more and more on how to correctly suspend works for non-payment. So rely on that. Don't get yourself into a bigger problem by carrying out more works and incurring more costs. It's a really difficult market at the minute, and we're seeing the effects of it. Certainly we've had quite a lot of comments in our chat box about bonds and the difficulties of providing bonds. I don't know, Sarah, if you want to talk about that.
Yeah, because you do the non-contentious side. I think you're seeing it more and more.
Yeah, absolutely. Bonds are almost always requested, but the issue that we're seeing at the moment, time and time again, is that, the obligation tends to come from the funder, and the wording tends to come from the funder and the employer, but the ability of contractors to actually obtain those bonds is so difficult. The bond market is so difficult, and what we're seeing is contractors being faced with the situation where they've agreed to provide a bond, but actually when they come to place it, even if they've agreed the wording during the negotiation stages, when they're coming to place it, it's just not available to them. So that is very, very difficult. I think one of the questions I'm just reading here is withholding a 10% sum only, and should the withholding provision reflect that the bond sum is only 10% of the contract sum, so it's unreasonable to withhold the whole sum. And from a contractor's perspective, I completely agree. The issue that we always come back to is that providing the bond is a requirement of funding. And if we're not getting the funding drawdown, no one's getting paid. So that's why it's always a full withholding provision. So what can you do? Obviously, if there's a bond requirement, agreeing the wording early with your surety is absolutely essential. And getting the correct wording in the contract that surety has actually agreed to provide, which, to be honest, at the moment is usually the standard ABI wording and not much else. Is something that just has to be agreed at the outset. Another option, and it's something that we've dealt with here, is to hold the bond sum in escrow. So rather than take out a bond, hold that sum of money, get your solicitor to hold that sum of money, and then it's paid out. Essentially, there's an agreement to say that it's paid out in the same way as a bond would and for the same reasons, but the bond itself doesn't actually need to be obtained. Alternatively, there's the provision for hire retention. Again, not a popular one with contractors among you, I'm sure, but can be a way of getting around the bond issue.
Yeah, no, definitely. That's exactly what we've seen. It's just
so hard.
Very, very, very difficult market, and it's been very, very difficult quite recently as well, hasn't it? It's not been a gradual thing.
Yeah, no, it's very recent.
I think also it's not just bonds. We're seeing insurance being difficult to obtain throughout the chain. I don't know, so if you want to talk about that as well, because it's much more your end of it.
Yeah, no, that's right. Another key problem we're seeing is PI cover. Again, I'm sure many of you are currently feeling this pain, but obtaining PI cover is not only difficult but very expensive. It's more and more in the aggregate basis rather than each and every claim, or is subject to fairly significant aggregate carve-outs. The issue contractually is that often the main contract sets out the various different levels of PI. And again, and I know I've sounded a bit like a broken record, but it comes down from the funding agreement. The funder says, we want all of your supply chain to hold 5 million PI cover on an each and every claim basis. That gets written into the main contract. And then, of course, when you come to engage with your supply chain, you find that that PI cover is just not available, and certainly not available to them at a commercially reasonable price. So again, it really comes down to understanding what's in your contract and making sure that those obligations aren't absolute and that there is some wriggle room for you to be able to go back to the employer, and equally for the employer to go back to the funder to say, it's not available on that basis. This is what we can get, because it is really is, you get what you're given, kind of a market with PI. Otherwise, it's about engaging with your supply chain early and making sure that if that requirement is absolutely on you, are you really engaging with supply chain who can provide it? Because again, you don't want to be stuck with an obligation that you just cannot comply with.
Yeah, no, that all makes sense. We've had a couple of questions in relation to covering any tips on how to influence the funders where insurances and bonds, etc., just aren't available.
That's difficult. Unfortunately, funders don't seem to understand this point always. That the market's very, very difficult. But yeah, it's just about engaging early.
I think they're going to realise at some point.
Yeah,
it's just a case of when.
Yeah.
Yeah. But they haven't realised yet.
No.
Despite, they just haven't realised yet.
And you can understand that they do want to protect their position, but when these options aren't available, they're going to have a rethink on how they approach things. And I think you're right; it will come to light soon enough that there's going to have to be a shift.
Well, there won't be any developments, will there?
No.
Yep.
So no real tips, I'm afraid, on how to influence the funders. Just hoping that they take a sensible approach.
We've asked a question about where fluctuations don't apply and the contractor's ability to recover inflation costs under a loss and expense claim. Obviously, the purpose of the loss and expense claim is to claim your actual cost in relation to the extension of time. So I think the honest answer to your question is it'll be quite fact dependent in relation to how that loss has arisen. But obviously, as matters stand, you are claiming your actual losses. But question mark is whether or not you can pull all the factual evidence together which supports a claim that you're entitled to an increase in your loss and expense claim. Questionable.
Worth a try,
I would say. And we've been asked about the slides. Now, as far as I'm aware, you will be able to access the slides. I think they go on a website.
I think so. We will make sure that they are available at somewhere.
But I think we are kind of bang on 11 o'clock now. So thank you ever so much for joining us. I hope it's been of some use to you. Obviously, you know where we are. So thank you very much and have a good day.